Hello friends, in the series on income tax cases, today we will discuss a case in which a very pertinent issue was before Honorable Delhi ITAT bench, and the issue was that if a assessee provides some loan to its wholly owned subsidiary company in the US and charges the rate of interest which are linked to LIBOR, but the assessing officer during the assessment proceeding, just on the basis that these loans are unsecured and the financials of the borrowers are very weak, making some positive adjustment in the interest charged by the assessee by ignoring the vital fact that the same interest rate has been accepted by the department in the previous year assessments and the subsequent year assessments. So the issue was that whether the assessing officer is justified without demonstrating any change in facts regarding the risk factor in the loans can make a positive adjustment. This issue has been decided by the bench in the case of Uniparts India Limited versus Deputy Commissioner of Income Tax, and this case is reported in 138 ITR Tribunal at page number 25, and the date of the judgment is 25th March 2026. In the present case, the assessee has established a wholly owned subsidiary in the United States and provided the loan to that company and charged the rate of interest which were very much linked to the LIBOR. When the assessment proceedings for the assessment year 2009-10 were going on, the assessing officer was of the considered view that in the present case the loans has been provided to the subsidiary company whose financials are very weak, and since these loans are unsecured, so the assessing officer made some positive adjustment in the rate of interest and made the addition by following the due procedure of the transfer pricing, and which was upheld by the dispute resolution panel also. The contention of the assessee was that these loans were taken in the prior years and no addition has been made by the assessing officer in the previous years and in the subsequent years, and there is no change in the risk factors. So no positive adjustment should be done, but the assessing officer was not convinced with the submissions of the assessee and upheld the addition. When the matter was before the tribunal also upheld the order of the assessing officer. So the assessee filed the appeal before the Honorable High Court, and the High Court remanded the matter back to the tribunal for determining the arm's length price of the interest on loans. In the second round of litigation, when the tribunal heard the matter, the tribunal was of the very considered view that in the present case there is no denying the fact that the loan has been provided by the assessee to its wholly owned subsidiary, which are under the direct and immediate supervision of the assessee. The tribunal said that in the present case the interest rate which has been charged by the assessee from the subsidiary company are very much consistent with the earlier year and the subsequent years, and in the present case no question of higher risk involved justifying a positive adjustment. The tribunal said that it is also a very established fact in the present case that no adjustment in the previous year and the subsequent years has been done, and the tribunal was of the view that although the principle of res judicata is not applicable to the income tax proceedings, but the principle of consistency holds very much in the income tax proceedings. In the present case, since the assessing officer has not brought any record, has not brought on record anything or any evidence which talks about the change in the risk factor involved in the current year about the loans given, so no positive adjustment should be done. So in the second round of litigation, the tribunal deleted the addition made by the assessing officer on the ground of consistency, because no addition has been made by the revenue authorities in the previous years and in the subsequent years, but a very different view was taken in the assessment year 9-10, which was turned down by the tribunal. At the end of this video, once again I am repeating the name of the case. The name of the case is Uniparts India Limited versus Deputy Commissioner of Income Tax, and this case is reported in 138 ITR Tribunal at page number 25, and the date of the judgment is 25th March 2026. Thank you, friends.